Thank you for allowing me to speak again today. I'd first of all like to thank everybody that has gotten these monsters off the street for my son. I really thought all of this was behind us, but that would be wishful thinking. There's always going to be appeals, parole hearings, and whatever else they decide to use the taxpayers' money for. This person doesn't deserve any of it. I hear life sentences. Your Honor, the only one that got a life sentence was my son. He comes in here with a big old smile on his face like he's going to a birthday party. There's no remorse. He doesn't care about my son. He doesn't care what happened to my son. I do.
This is one of the most powerful moments in any sentencing hearing. A victim's family reminding the court that while the law talks in years and numbers, their loss is permanent. When she says, "The only one that got a life sentence was my son," that's not rhetoric. It's the emotional truth judges are legally allowed to weigh under victim impact considerations. And notice the contrasts she draws, grief versus a smiling defendant. That contrast matters.
But I'd like to tell you today, Your Honor, I'm in a much better place. I actually celebrated Christmas this year with my family. We did all the things. We did cookies. We did presents. I enjoyed it all. I'm looking forward to making so many more traditions and making memories. I'm at peace now. I will always hurt for Chris immensely, but I also know he is at peace now. And now that all these monsters are in prison, Your Honor, this person is never going to stop hurting people. Whether he's in prison, he's out, it doesn't matter. And I'd just like you to think, whether he's 65, 85, he's not going to change. He's going to get worse. With his prior record, honestly, he shouldn't have even been out to have made this happen to my son. I have so much more to say, but Your Honor, all I can say is, don't let this person ever get out. Don't give him a chance to ever get out. I don't want another family to go through what I'm going through. That's all, Your Honor. Thank you.
Defense asks you not to use acquitted conduct to fashion a sentencing, which I agree, the court can't do that. However, this court sat through weeks of testimony, sat through the trial, heard all the testimony. The guidelines are 365 to 1,200 months. I'm not good at math, but I believe that's 100 years on the top end of the guidelines, Your Honor. As well as the fact that the gang charge could be stacked if this court wished to do that. And the prosecutor's office has requested that. However, this court fashioned a sentence that they believed was appropriate. I would ask the court to continue the sentence that this court imposed the last time, as that would be an appropriate sentence. Yeah.
This is where the case shifts from emotion to pure law. The defense is arguing a critical rule. Acquitted conduct cannot be used to increase a sentence, and the judge agrees. But here's the key detail many viewers miss. Judges can still rely on trial testimony, sentencing guidelines, and legally proven conduct. That's why you hear numbers like 365 to 1,200 months. This isn't guesswork, it's structured discretion.
This is a resentencing, obviously. And at the time of the initial sentencing, we did ask the court to consider consecutive sentencings. And I'm going to approach it from that perspective briefly here. Since the time that Mr. Trevino was convicted of sentence back on June 16th of 2023, a few things have happened. The Court of Appeals vacated 2 of his convictions on jury instruction and issues and other technical grounds. And maybe more importantly, Andrew Cecil pled guilty to manslaughter and felony firearm charges. In his factual basis for his guilty plea, Cecil verified in summary a great portion of what Austin Richardson testified to during his trial testimony and his preliminary examination testimony. And without explicitly naming Mr. Trevino in any capacity whatsoever. But certainly Mr. Trevino's jury spoke to all of us, Ms. Dickerson, the court, etc., on that particular issue. And this court, when it sentenced Mr. Cecil, did speak on the issue of consecutive sentencing with very sound and solid logic and, frankly, Judge, genuine eloquence. You indicated that Cecil's desire to prevent Dickerson from testifying in the assault case was an attempt to subvert the judicial system. You stated, quote, "In this case, it's particularly true where we have a justice system that is designed to try to find the truth when charges are made. And in this case, Christopher Dickerson was murdered in an attempt to hide that truth. Along with the attempted harm to the judicial system, you indicated that the consecutive sentences were appropriate for Mr. Cecil because both cases involved the same victim." Now, I have personally stated before in this court that it was Andrew Cecil who lit the fuse that directly resulted in the murder of Chris Dickerson. But it was Count Teresa the Almighty Trevino who figuratively provided the fuse, the matches, and the manpower to cause this murder to come to fruition. Amongst Mr. Trevino's 11 prior felony convictions and 5 prior misdemeanor convictions are convictions involving shootings and witness intimidation. And while it is 100% true and accurate that Trevino was nowhere near the original assault of Dickerson, everything that happened thereafter, everything that led to Dickerson's murder belongs to Trevino. He owns this murder. Proudly. Make no mistake, the murder of Chris Dickerson simply does not occur without Mr. Trevino's consent, approval, and advice. He directly and materially aided and abetted this murder. Our legislature has given courts a tool, the ammunition it needs to make a true statement of deterrence when consecutive sentencing is appropriate. As the leader of the local Latin Count gang, Trevino's actions fits squarely into the scope of the legislature's intent. We still absolutely believe, Ms. Dickerson, Ms. Wise, myself, law enforcement, that consecutive sentencing is not only appropriate, it's justified. We already know that Tracy will never forget Chris. But once and for all, let's make sure that Count Teresa, the Almighty Trevino, doesn't forget him either. Thank you.
In determining the appropriate sentence in the case, the court has considered the seriousness of the offense, your history, principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Trevino is 41 years old. He has 11 prior felony convictions and 5 prior misdemeanors. He has a juvenile adjudication for arson. He has 3 convictions for discharging a firearm in or at a building. He has a conviction for felonious assault, a felony firearm conviction, a bribing, interfering, or intimidating a witness conviction, conviction for assaulting a prison employee. In 2016, Mr. Trevino was convicted of accessory after the fact to a felony. He violated his parole numerous times and was pending a parole violation at the time that he committed these offenses, second-degree murder and gang membership felonies. The only rational conclusion from Mr. Trevino's criminal history is that he is an assaultive, extremely dangerous person who poses a serious risk to the public, is not interested in rehabilitation. His prior record variable score is 147. That's 3 points shy of being twice what it takes to reach level F, which is the highest level on the M2 grid. He's been placed on probation and violated. He's been given 8 prior prison sentences and committed an additional felony while in prison. He was paroled, violated, and then committed this offense. He's been undeterred by previous sentences. Other than obtaining a GED while in prison in 2002, the record before the court contains little, if any, evidence that Mr. Trevino has done anything to rehabilitate himself. The nature and gravity of these offenses, particularly the second-degree murder conviction, could hardly weigh heavier in favor of a strong punishment than they do in this case. What's more serious than, or more grave than murder? Nothing. And when we compare this second-degree murder to other situations that also constitute second-degree murder, this ranks at the more heinous and perhaps most heinous end of that spectrum. This one occurs in the context of a criminal gang enforcing its rules and preventing a person from testifying in a criminal case against another member. That is the evidence in this case, and it implicates more than just a loss of Christopher Dickerson's life, which is the ultimate tragedy. It harms societal safety, it creates fear and anxiety in the community as a whole, and it injures the ability of the justice system to function. And those factors make this case far more serious than most second-degree murders. A 25-year sentence is...
Listen carefully here. This is the court explaining why this murder is different, not just because a life was taken, but because the killing was meant to silence a witness and protect a gang. That crosses into an attack on the justice system itself. When courts talk about deterrence and vindication of the law, this is exactly what they mean. The sentence isn't just punishment, it's a warning.
Is not proportionate to the intentional killing of a 26-year-old young man who had far more than 25 years left to live. 25-year sentence is not proportional to the criminality that took place in this case. It's not proportionate to a young man being walked into the woods, shot in the back, and left to be fed upon by wild animals. 25-year sentence is not proportional to a person who has had numerous opportunities to rehabilitate before being convicted of murder. 25-year sentence is not proportionate to a murder that occurred to enforce gang rules and prevent a witness from testifying in court. The original sentence given on this second-degree murder count was 45 years, and I believe that is far more proportionate and is proportionate to the offense that occurred, which, as I've discussed, has had more aggravating factors than any second-degree murder that I'm aware of. And it's also more proportionate to the offender, who has an extreme criminal history and who has rejected all prior attempts to rehabilitate himself. Indeed, as Ms. Wise said, the upper end of the minimum guidelines is 100 years, and a 45-year sentence is less than half of that. And as a result, I believe that every day of that would be proportionate to the offense that occurred in this case and the offender who committed that offense. With respect to count 1, second-degree murder, it's a sentence of the court that Mr. Trevino served 45 to 85 years with the Michigan Department of Corrections. Must pay restitution in the amount of $2,490.40 to Tracina Dickerson. Must pay $130 crime victims assessment and a $68 state cost. With respect to count 4, the gang membership felonies, it's a sentence of the court that Mr. Trevino served 10 to 20 years with the Michigan Department of Corrections. You must pay a $68 state cost. As I said at the first sentencing, and I continue to believe here today, I think that concurrent sentences are appropriate given the nature of the sentence on the second-degree murder charge. And so I will continue to run those sentences concurrently.
Thanks for watching.